We hope you enjoy this episode of the Modern Arizona podcast. But first, an important message for our listeners.
Hello and welcome to the Modern Arizona podcast. You may have noticed we recently changed our name from the Modern Divorce Podcast to the Modern Arizona Podcast. Recently, our topics have gotten broader than simply divorce and family law related into topics that all Arizona families, professionals, and individuals might care about. So in keeping with our expanded scope and what you, our listeners, want to listen to, we are now the Modern Arizona Podcast. Hello, this is Billie Tarascio, owner of Modern Law. We are a family law firm in Phoenix, Arizona with offices throughout the state. We've got attorneys who can help you with every aspect of your family law case. We have a legal clinic run by students for those of you who need budget-friendly resources. And we've got lawyers who've been practicing for more than 20 years. Collectively, Modern Law has more than 200 years of attorney experience. So when you hire Modern Law, you're not just getting an attorney, you are getting a team. If you live in Arizona and you need representation, call us at Modern Law today. That's 480-649-2905, 480-649-2905, or visit us at mymodernlaw.com. Hello and welcome to a very special episode of the Modern Arizona podcast. Today I am joined by Maricopa County Office Attorney Rachel Mitchell. Welcome to the show.
Thank you very much. Thanks for having me.
I really appreciate you being here. Really, really appreciate it. And there are things we could talk about so much for so long, but can we just start with, what do you think is going on with youth gang violence?
Yeah, we're seeing versions of it that just really are not what we have seen. As you know, I've been a prosecutor for 32 years, and the old traditional, if you will, look of gangs has changed. So that some people are taking to using the word hybrid gangs, but they used to be geographical, they used to be racially homogenous, and they're not now. These are people who keep in touch through social media, so that obviously is playing a factor in it. We know that from talking to ACJC, for example, that a lot of what the commodity is, it's not drugs or money necessarily. A lot of times it's street cred, if you will, or social media fame or presence. And so you're seeing disconnected groups of people that are connected through social media that are seeking different reasons for doing this. And I can't help but say, you throw in what happened during the pandemic, that's got to be a factor as well.
So we typically expect that this type of behavior comes from low income, disadvantaged, struggling kids. And now what we're seeing is children who have everything that they need in the traditional sense, who are banding together and engaging in violent behavior. And it's not just the goons.
It's not just the goons, and it's not just the Southeast Valley. And and I don't want to overstate this, but so that it's, I don't want to diagnose or anything, but there's a decided lack of empathy, and there is an absolute sense of entitlement that we haven't seen to the same degree in the past.
The next thing I want to talk about is the relationship between the cops and the prosecutor's office. So people are very, very angry here in the Southeast Valley with both the cops and the prosecutor's office, and the roles of each tend to be muddied. So can you talk about that for a minute?
Sure. I mean, I'm not being glib when I say, you need both parts. It's like Law and Order. The first half hour is them, and the second half hour is us. But I mean, we work together really from the moment that the police officers let us know that there's a case going on. we are on call 24 hours a day, 7 days a week. We don't provide legal advice, but we do go out and so that we can walk the scene, we can, see how the investigation is coming together, et cetera. It's very, very valuable. But in this case, it was a little bit different, and not in a bad way. You have Queen Creek that was investigating, and of course, we all know by now that there was no videotape of the homicide of Preston Lord. And so you had police trying to find out, is there a video? Who was a witness? Who's going to cooperate? Who's not cooperating? And, with all of the rumors and the things that were going around, some people were very hesitant, and I certainly understand this, to cooperate. And so one of the things that we did is we came alongside when we got the submittal in late December, and we started an investigative grand jury. That's not something that we do frequently. But what that allows us to do is to subpoena witnesses who are not suspects to come in front of that grand jury and be interviewed. And it becomes a little tricky to navigate the media with that, because I can't get up and say, we're conducting an investigative grand jury, because that would be actually a crime for me to say that. But it does provide a very valuable tool in terms of getting people on the record to cooperate. And the result of it was, while Queen Creek was able to submit for charges, and I'm talking about the homicide charges, for 5 kids, we were able to develop 2 more. And so we indicted for a total of 7. They weren't all juveniles, so defendants.
And I do want to talk about that, but I want to back up even further. So recently, Connor Jarnigan's police report came out, and in Connor Jarnigan's police report, it showed that clearly there was a group of kids going around targeting other kids for fun in violent behavior, and it identified who they were, and it wasn't stopped. So was the prosecutor's office brought in at that point?
No, we're brought in either when we're called into an investigation. So like a homicide case, we were called in. We're not called in typically on every crime because we simply don't have the manpower. And this case was not submitted to us for charges, so we weren't brought in. But I am aware of it, and we can talk about some of the reasons for that. I've seen some of the cases that were not acted upon. Some of what we saw there were bits and pieces, but not a whole complete picture. So for example, I know that there was one video that the police had that showed a girl beating another girl. And they knew who the defendant is, but they didn't know who the victim was because the victim hadn't come forward. Well, actually, our investigators from my office got involved, and through other means were actually able to identify the victim and contact her and say, are you the person this happened to, and make a case out of it. So sometimes you have something that's very disturbing looking, like these videos, but people need to understand a video does not necessarily equal a fileable case, because you may not know who everybody is that you need to know.
So with regards to that video, is the victim willing to press charges?
Yeah, actually, she was, and we did file charges against the female who was doing the attack.
Okay.
Mhm.
All right. So another issue is that police had information and pictures and photos, but they didn't identify the people in them. If we look at Tristan Keener's attack, that was very, very clear. And within hours of putting out these videos and photos, the people involved were identified.
Mhm.
Why wasn't that happening?
I can't speak to that entirely, because obviously we are a separate entity from the investigation. But I will tell you, one of the things that I've seen is that people are posting a lot of videos to social media. And we're actually, because of that, starting a campaign. We're going to be kicking it off closer to the school year starting, called Don't Repost, Report. Because what's happening is people on, let's say, X are posting a video saying, look at this happening. And maybe I see it, maybe a police officer sees it. We don't know who any of the people involved are. We don't know even jurisdictionally where this happened. And I mean, I'm thinking of one case in particular. And so one of the things that we really want to urge people to do is don't just put it on social media, call the police, because you're going to be able to give us more information about who these people are, where this happened, so that we know which police agency should investigate it. One of them, you could tell it was happening on school grounds, but you didn't know which school. So it's very important that people don't substitute X or Instagram or TikTok videos for actually calling the police. We still have to do good old fashioned police work.
Well, we would love that, but it doesn't, there hasn't been a lot of good old fashioned police work on some of these cases.
I understand that. And I can certainly understand why people are frustrated. But that is still very helpful to the prosecution part of it, where we're able to establish who these people are.
Going back to Tristan Keener's attack, there were two juveniles that Maricopa County Prosecutor's Office declined charges for. Two
Mhm.
juveniles that Tristan Keener identified, one of whom had a video. It is very difficult to see why you've got Taylor Sherman, who is being charged with first-degree murder for taking a video, and another juvenile who took a video, and we declined charges.
Mhm. Well, without going into any detail on the Sherman case, because it is an active case, what I will say is taking a video in and of itself does not make you prosecutable for the offense. Now, it's certainly evidence that you're there, that you're participating maybe in some way. But we're also listening for what statements were made on that video when the person was taking the video. If you have a situation where somebody is merely videotaping it, in this day and age, everybody's got a video camera on them, in by way of a phone, and that does not necessarily equal criminal charges. And so one of the things that we've done in our office is we have looked at, we have done what's called an incident review on each of these cases, which means that I sit down with not only the assigned prosecutor in their chain of command, but also the senior attorneys within my office. And we watch the video and we are extensively briefed on the police reports and what's going on there to decide whether there's a reasonable likelihood of conviction. And sometimes the video just does not show what we need for criminal charges. And we also take into account the victim's statements, and victims can put people at the scene, but absent the victim saying the person participated specifically, that makes it more difficult. So, I mean, we run a fine tooth comb through every piece of evidence available to us.
This is Billie Tarascio, owner of Win Without Law School and Modern Law. Win Without Law School is a program that operates nationally and helps people who are representing themselves or who just need more help. If you are in a family court case and you're feeling confused, you need direction, you need help figuring out questions to procedural or strategic issues, Win Without Law School can help. At Win Without Law School, you've got two experienced attorneys, me and my partner, Julie LeBenz, who can guide you through the court process and help you troubleshoot your case. You've got access to courses, planners, checklists, and live Q&A. Our live Q&A is where you can get help from us and your community. We also have a closed Facebook group just for members where you all can share your experience, share your pleadings, get advice, and mentorship. Join us today at winwithoutlawschool.com. That's winwithoutlawschool.com. So if there is evidence of threatening and intimidation and cyberbullying, which I think has been rampant, but we're not seeing those charges. Can you talk to me about that?
Well, some of the charges that you're not seeing at all involve juveniles because it's not our office policy that we don't talk about juvenile crimes unless, of course, they're transferred to adult court, like in the Preston Lord case. So we are seeing some of that. We are taking that into account. It's not only usable as a charge, keep in mind, it's also usable as proof of another charge. And so, for example, if somebody is accused of an assault, a threat to stay silent about that assault can be used not just as a charge, but it can be used as evidence of the assault itself. And as you know, we've charged many people with assaults related to this type of behavior.
There is almost universal dissatisfaction with the outcomes of probation for these assaults. And I think it's really important we talk about it.
I do too. I would join that chorus. So one of the things that I have noticed that's happened is there's been a lot of information put out there that's not accurate. So I'm gonna geek out a little bit on the law here, but assault is anything. In Arizona, we have felonies ranging from 1, which is first degree or second degree murder, down to 6. And then we have misdemeanors from 1 down to 3. So 6 and the 3 being the least serious. An assault can be anything from a class 3 misdemeanor on up to a class 2 felony. And there was information put out by a certain radio show that I heard, and maybe others as well, that these were class 2 felonies. So in other words, the second highest felony that we have. That's actually not correct. And I'm not talking about the plea offers. I'm talking about the actual charges. In Arizona, if somebody beats up on somebody, unless there is serious physical injury, and that's very specifically defined. It's not what you and I would say is, well, that was really serious. It's very specifically defined. Unless it's serious physical injury, or there is, for example, a broken bone or permanent or temporary but substantial disfigurement, for example, it's a misdemeanor assault. Now, everybody can gasp at that and say, you know, that's awful. I will agree with you under these circumstances. That's not what it should be under this set of circumstances. So then you take a misdemeanor assault. What could have happened is we could have sent these beating cases. I'm not talking about Preston Lord, of course,
Right.
to city court for misdemeanor prosecution. What we did in the county attorney's office instead of that was we took a provision that can up a misdemeanor assault to a felony level. And what that provision is if you argue that the victim's ability to resist was impaired. Normally, when you argue that, you're talking about somebody who was tied up and hit so that they couldn't, you know, put their hands up, or handcuffed or something like that. What we argued in order to get it into felony, to the felony level, was that because there were multiple offenders. But that's not always the way that provision is thought of. That enabled us to get it to a class 6. So in other words, the lowest level felony. So these cases that are being pled down as it's being described are actually pleading to the charge. But the charge isn't very high because the law doesn't allow for that. One of the things that I want to do in the coming legislative session is to propose that in situations where we have a group of individuals, 2 or more individuals that are targeting someone with a beating, that be raised to a higher level felony. But at this point, it is a misdemeanor, and if you argue what we argued, a level 6. Now, one of the things about a class 6 felony that people need to understand is, for lack of a better term, a class 6 felony is kind of a purgatory, if you will, between a felony and a misdemeanor. So when somebody is charged with a class 6 felony, not only are they probation eligible, so they could go to trial and get probation, but they could go to trial and it could be designated a misdemeanor. So you're dealing with a single charge that could be designated a misdemeanor that certainly will get probation. And, we're getting felony convictions on these individuals. So to me, that speaks to very good efforts on the part of the prosecutors. They're not being light, they're being as harsh as they can be under the set of circumstances they're dealing with, which is the law.
That is hard to fathom because you've got cases where people's heads are being stomped, which
Yeah.
could seems like it could be attempted murder.
Yeah, I mean, and certainly we consider, intent behind that, and I mean all of the things. I mean, if you would be present during these incident reviews, you would hear a lot of, what about this? Is there this? Can we use this? But the reality is a lot of these are very disturbing, very bad situations. But because the law only allows certain things to be designated, the higher level felonies, they really don't rise to that level under the law. And that's why I think the law absolutely needs to be changed. And, I'm sure that, I mean, even in some of these cases where we've asked for additional jail, um, you know, not even prison, we've asked for jail, that we haven't gotten what we've asked for. And that's just the nature of a class 6 felony, unfortunately. And that's why it needs to be raised, because it needs to be treated more seriously by the system. But to be, as we started off with, we haven't seen this kind of thing to this degree in the past. And sometimes the law takes a little bit to catch up, but certainly the legislature needs to look at this in the next session.
Two follow-ups on this. What would make something a class 5 versus a class 6?
So a class 5 felony would be, for example, assaulting a police officer with no injury. So somebody who spits on a police officer would be an example. If the officer is injured, but not to a serious degree, it could be a class 4. If somebody is assaulted and maybe they're hit in the face and their orbital bone is broken, so you have a fracture, that could be a class 4. We didn't have that. A class 3 then would be typically somebody who is a gun or a knife, or they are seriously physically injured. So it doesn't have to be that the gun is fired. The gun can be pointed at the person to put them in fear, or they are the victim of serious physical injury. So serious physical injury is, like I said, legally defined. It's not what you and I would just say, well, that's very serious what happened. And then the class 2 felony is exclusively police officers where there is a weapon or serious physical injury used.
Okay. But if somebody's head is cracked open with brass knuckles, that's not a 6, right?
No, that would be a fracture of the skull, so that would be a 4 or potentially a 3, depending.
Okay.
Yes.
The
But
other question
it
I have
has to be
is
fracture, not split skin. It has to be fracture.
the skull has to be broken.
It has, the statute says fracture.
Okay. The other question I want to give you an opportunity. What is the case where you asked for jail time and the judge shot you down? Because I don't know about it.
Oh, there was one where we've been let me give you the name so I don't tell you the wrong thing here. So on the Jacob Pennington case, we asked for additional jail. One of the things, this is like kind of advanced prosecution, but on a class 6, you have to be careful, because if you get too much jail up front, then the person will just say, well, I've maxed out my time, so I don't have to serve probation. So we have to balance how much jail we ask for. So we've been looking to get 90 days. Sometimes we'll ask for 6 months. So we asked for enough jail to get it to 90 days. And we were turned down for that. So that's
With
why.
Jacob Pennington.
Mhm.
Okay.
Jacob.
Okay. I don't think I didn't know that. So we may have we, the public or the media, may have missed that. But it is.
If you go to let me give you an example. So in a class 6, let's say you get prison, which the presumptive or the starting point for a judge is 1 year, but in prison you get a 90-day early kick out on lower level type things. So that's, now we're down to 9 months. And then you only serve 85%. So now we're down, another month or so. And so if you ask for the full year, which is the maximum you can ask for, then you can't have them on probation because they've maxed out their time. And so that's something else we have to take into account.
Can I ask you, I'm going to share a screen. I want to ask you about this. There's a sentencing chart. Okay. So is this the correct sentencing chart?
Yes, I can't see too far down, but I recognize it. Yeah, that's
Okay.
yeah.
All right. So then are we falling under dangerous?
No, we're not.
Are we falling here? Non-dangerous offenses?
Yes, that is exactly where we're falling. Okay. What makes something dangerous is either a weapon or serious physical injury. So you're never going to have a class 6 ag assault dangerous, because by definition, if it was dangerous, meaning there was a weapon or serious physical injury, it would be a class 3. Does that make sense? Yeah.
So we have category 1, 2, and 3, and then there's minimums, presumptives, and maximums. Some are would be something not probation eligible.
So you need to go to the kind of orangish chart up above. So that's the starting point. So if somebody attacks somebody and nothing's broken, etc., and we charge a class 6 felony, they fall under that bottom level there, 0.33 all the way up to 2 years. With that probation category is how many years on probation they can get. It's not a prison sentence. Now, the way you get into the repetitive offenses is, let's say I beat somebody up on day 1, and then I go beat up somebody on day 2. So day 1 is sentenced under the orange area. Day 2 could be sentenced under the, I'll say, white area or category 1. It's the same sentence, it's just not probation eligible. But that's only for the second count, not for the first count.
Okay, so then with someone like Jacob Pennington, or even Jacob Meisner, many of them, there are different incidents that they're being charged in, and they seem to be getting probation in each one.
Jacob Pennington had one case here, and he had one case in Pinal County. Both were class 6s. And one of the things that is also, I'll say, annoying about a class 6 is, even if you look at the sentencing chart that says second when you go to prison, if you knock that first one down to a misdemeanor, you're now back into the orange area, if you will. And so that's a very real situation that we see all the time in court.
Were they knocked down to misdemeanors, or how does that happen?
The judge can do it. There's a statute out there that talks about that a class 6, until it's designated as one or the other, is treated as a misdemeanor. And so the judge could go to trial here. Let's say the first one happened here. So if he's probation eligible in Maricopa County, he goes to trial, the judge could knock that down to a misdemeanor. And then when he goes to trial in Pinal County, there's no prior felony conviction. And so they're not moving to that category 1 that is that not probation eligible part. They're stuck in a probation eligible thing. And I can understand why listeners are going, oh my gosh, this is awful. Who would do that? It does happen a lot. And one of the reasons it happens is they look at the fact that these are young people. That is considered a mitigating factor. Whether you or I consider it a mitigating factor, it is a mitigating factor, that they were operating with others. And while I would argue that is an aggravating factor, because I think people tend to behave badly in groups or worse in groups, I think we know that. I think some people might consider that mitigating in the sense that they would say they were going along with the crowd, and but for the crowd, they independently wouldn't have done this. That could definitely go the other way. And all of this to say, that's why this needs to be treated when they are operating as a gang like this. And I use it small g gang, a gang of kids. That's why this needs to be treated more seriously, because you can see what happens most tragically when they get together and target some individual. We have a dead 16-year-old, and I've met with the parents, and I can't imagine sending my kid to a Halloween party, or thinking I'm sending my kid to a Halloween party. And I told his mom, I said, when you're prosecuting cases, it's not uncommon for somebody to say something unkind about a victim. That's not, for whether it's true or not, you hear unkind things. And I have not heard an unkind word about Preston Lord. And it's just unthinkable.
Why haven't gang enhancements been applied? How can we say there's a gang?
Yeah.
How their behavior is, and then call it a 6?
I can't, gang enhancements aren't going to change the level.
Okay.
What they will do is they'll tack on a little bit to the sentence, but there is a statute that talks about what the gang indicators are. And what I will say is that when we went for charges against these individuals that attacked Preston, a full presentation was made to the grand jury. And they're very aware, grand jurors are aware of gang enhancements, and they did not choose to impose those. I can't say...
It wasn't designated a gang at that time.
Not at the time of the homicide, no. But that...
Or the grand jury, right?
I think... I'm trying to think how that happened, but no, I think it was. But we did do a full presentation on the gang indicators in the case. I think maybe, and I'm trying to get into grand jurors' heads here, I think maybe it's because this doesn't look like gangs do in our minds. And we as a society need to start realizing that gangs are not looking like they used to.
And it almost seems more important that the Christopher Fantastics and the Penningtons have the gang charges than the Preston Lord defendants, because the Preston Lord defendants are already facing life in prison.
And that's something that we're constantly, because for example, we had a couple of individuals, Jacob Pennington is one, reoffend. When I say violate probation, and
Right.
It was fascinating to me because he did it the night that he was sentenced, and we immediately filed a petition to revoke his probation, because by the time when you're sentenced, you haven't gone immediately to your probation officer, so you haven't been signed into probation, so to speak. And people were critical that we acted instead of waiting for the probation department to act. But the probation department had said, we're not going to do it because we haven't really signed him into probation at this point.
Why would people be critical?
I think they were acting like it was some sort of unusual thing. And it's not typically we rely on probation department to do that. But under this set of circumstances, it was not at all unusual to do that because of the timing. And it was interesting. People were trying to make it like some sort of sinister act. And it wasn't. It was simply probation said they weren't going to do it. The timing was such that it was, and we went and did it. So I think sometimes people are trying to find things that aren't there. That was just, we did our job. So
I still don't understand, and maybe I can't, but why can't gang charges be applied to these group beatings?
They can, but the charges So the way things work is we review whatever is submitted to us by law enforcement, and we decide what charges that we think might be there. When a case is presented, and I'm speaking generically at this point, to a grand jury, we can present them with what's called a draft indictment. In other words, here's the indictment that we put together. Even if you present them with a draft indictment that has gang charges included, they are instructed under the law that those admonitions, they've been read a whole set of admonitions concerning draft indictments apply to you. And what those admonitions say is you can accept the indictment in whole, in part, or you can reject it in total. And that means that they can say, we're going to indict on all the charges you suggested, but we're going to ask you to take off the gang charges. So they can do that.
So has that happened with the non-Preston Lord Gilbert Goons cases, that the gang enhancement has been rejected by the grand jury?
I'm not allowed to talk about specific testimony that occurred within a specific grand jury, but I can tell you generically how things have gone.
Wow. Okay.
Or can go.
Information. Good information.
Yeah.
Okay. Why has the department chosen not to press charge against the homeowners in the Preston Lord murder?
That decision has not been conclusively made yet. We focused primarily on the homicide. So we originally, the submittal that we got were 5 individuals for the homicide and then 2 homeowners. And then we were able to add 2 additional people for the homicide. We prioritized the homicide. And as you remember from my press conferences back in the day, we were working our way through a 2,000-page police report, and it became more than that. And I forget how many, 600 videos. And we prioritize that, and we are doing a little bit more investigation through the process. Understand that as one case is moving, meaning the homicide case, other information is being developed, and so we will make a decision on that. But we have prioritized the physical violence.
Okay. So when Queen Creek submitted charges, and I understand correctly, they recommended second-degree murder charges for Talon Runner, Preston Billy, and Jacob Meisner.
Mm-hmm.
And that they recommended additional robbery charges for Dominic Turner and Jacob Meisner for the stealing of the necklace.
Mm-hmm. There was the third one too. There were 3 that were indicted for the robbery.
Okay. And then there was no mention, I think, of Talon Vigil or Diversion.
I think that's correct.
Okay, so how do we go from those recommendations, which are probably the most obvious and the most logical, to first-degree murder for everyone?
So there are one of the things that people should understand is there are 2 ways, if you will, to commit first-degree murder. One is what on TV. It's the premeditated murder. And obviously, to show premeditated murder, you have to show that really that was the plan.
Right.
But there's a different kind of first-degree murder, and that's called the felony murder rule. And felony murder means during the commission of certain felonies, not every felony, but certain felonies, a death occurs. And so that gets you to that point where you don't have to show that it was premeditated. What you have to show is they were busy committing another offense and someone died. And so what these 7 individuals are charged with is felony murder. And the felony that makes the basis of that is the kidnapping. And that has to do with restraint. And then as far as the robbery charges, not everybody was involved in that particular act. So those that were charged. And I do need to stop and say here to the public, these are charges. They are not evidence. People are presumed innocent until proven guilty in a court of law. And so understand my comments in that light. I'm talking about what we believe the evidence shows.
Why aren't the other victims given the courtesy of the kidnapping charge?
That has to do with a matter of degree. What was described to us is we have the videos of some of the others, but we do not have a video of the homicide. But based on what was described to us, we felt like the kidnapping charges were appropriate.
So it was different. What's happened to Preston was different.
More extreme, certainly. Obviously.
But what makes it kidnapping?
What makes it what?
Kidnapping.
Oh,
Versus these other cases where people are swarmed and they can't move and they're being beaten by all angles.
and that's what we use to get it to that felony aggravated assault. It's a restraint. So it's a little bit of a different language. One is the ability to resist is impaired. That's what makes it the felony, classic felony. What kidnapping requires is actual restraint. So being surrounded is a little bit different. And we're also anticipating how is the jury going to interpret this evidence? What is there a reasonable likelihood of conviction for? Is different than, obviously we can all hear it's a stronger requirement of restraint.
So there's also been a lot of talk, and I'm not sure if you can talk about this, but what are reasonable plea agreements going to look like? And I'm asking this because I just read an article where a man in Bisbee shot his sleeping wife, called 911, confessed to killing her, and he pled guilty to manslaughter in about 10 years. Is that normal? Is that what we're looking at? Is that kind of how this system works?
I don't know anything about that case, so that's hard for me to talk about that case. What I would say is this. In these types of cases, this level of seriousness, and I'm not just talking about those related to Preston Lord, we staff it at the highest levels within the office. And we're looking for a variety of things. We're looking for what does the law allow, obviously? What is the judge likely to do? What are the mitigating factors, like we've talked about in terms of the age of the person? We're looking at what is the evidence? And I'm not speaking specifically to the Preston Lord, but obviously something being on video is very different than something not being on video. You also have a situation that I talked a little bit about during my press conferences where when people film something has already happened. Because you and I don't walk around with our cameras just running, hoping something happens in front of us. So something has already happened, and somebody then pulls out their phone and starts recording. So by definition, we get that recording midway. So then you're looking at what people see on the media is from here on out. But what we have to take into account is what are people saying happened back here? And I'm not talking about any case in particular, but you may see somebody wailing on someone in a video, but what's happened in the previous 10 seconds is somebody pulled a gun on them. Like I said, I'm not talking about any of these cases. I'm just giving an example so that people understand context is important because I have to take these cases, my attorneys have to take these cases in front of a jury of 8 or 12 people. And we have to get unanimous agreement beyond a reasonable doubt that these specific acts happened. And that's why we are very cautious about how we proceed. We want to make sure we have the evidence to back it up.
So do you have any predictions or any information about what plea agreements might look like?
In the Preston Lord cases? No, I don't. And we're pretty early on in the process to really even think about that. Obviously, these are very serious charges, and they will be treated as such. I mean, it's funny, I was at an event the other night, and somebody said, "You're giving these people class 6 felonies." And I said, "No, these are the other cases, and they are class 6 felonies. Preston Lord, all of those suspects are still completely charged and have not pled to first-degree murder."
Preston Lord's parents filed a wrongful death lawsuit yesterday. how does that civil suit impact a criminal case, if at all?
Preston Lord's parents have been very wonderful to deal with during this process, and they have a set of attorneys, and obviously that set of attorneys is very aware of that a lawsuit might be used in some way to make it seem not as serious. Like, oh, you're getting money, or you're in this for the money. The way that it could be used, unfortunately, in court. But it was our feeling, county attorney's feeling, that the parents are not witnesses really here. They're not witnesses to what happened, thank God. And we were confident that if they want to go ahead with that, then that they're certainly able to go ahead with it.
Got it. So you don't believe that there's any impact, really?
Well, there's always a defense. Somebody's always going to try to make something of things. That doesn't mean that it will be successful. And so some of it is just my experience, as I'm an experienced trial attorney, judging how this will play out.
Does the civil suit allow them to discover evidence collected in the criminal suit?
Yes.
So they will have access to all of the evidence that you and the defense attorneys have?
Yeah, they'll probably do it through a combination of public records requests, subpoena, that type of thing. But yes, they will have access to that.
I want to turn to some of the things that your opposing candidate, Gina Godby here, mentioned on my podcast, specifically about your diversion program.
Mm-hmm.
She has said that your diversion program is incredibly liberal. I don't know if there's a better word, but broad. And can you address that?
Sure. The diversion program has existed in our office for many years. And what it is for low-level offenses, it is not for, and I'll use this as you and I would just colloquially use the term serious offenses, for people who have, for example, mental health issues, or people who have substance abuse issues. And the goal of it is to get the person the treatment they need and get them so that they're not crushed by the system. So, for example, someone who has a substance abuse issue, and we could prosecute them, and they could have a felony on their record. Possession of, for example, fentanyl is a class 4 felony, and they can have a felony on their record. They could be put on probation, which has gotten, in my opinion, quite a bit more lenient lately. So our diversion program actually has more rigorous requirements. Then they come out on the other side and they have a felony conviction, and we say, good luck, stay clean. Now this person has a harder time getting a job, and they have a harder time finding a decent place to live, which does not lend itself to sobriety. On the other hand, if they go through a more rigorous treatment program and they come out on the other side, they come out without a felony conviction. And what my opponent is saying that is incorrect is this. She's saying half the people, if they don't succeed in the diversion program and they're back out on the streets committing crime. That's incorrect. The people who do not succeed or agree to do the diversion program or do not succeed in the diversion program are then prosecuted. So they are not just turned loose and we say, oh, but here's the incredible statistic, I think. For everyone that completes diversion, we have done a 2-year follow-up. We hire a statistician to do everything you and I went to law school to avoid, that being mathematics, right? And in the 2 years after they successfully complete diversion, they are rearrested less than 9%. Now, you show me a criminal justice system program that has that kind of outcome, and we'll do that instead. But this is to help people. We have one for veterans who are dealing with PTSD. Like I said, mental health issues. The first veteran graduate of our diversion program said, I think it saved my life. And that's what we want. You can't put everybody in prison that comes through the criminal justice system. And also, you can't keep them there. Some people are going to get out and go back into society. And this is a way to ensure that they are successful. But it is not for, as I have heard, robbery, or it's nothing anyone would say, oh my gosh, I can't believe you would give that person diversion. No.
One of the things you said reminded me, I meant to ask you about Tyler Weiner. He was arrested or stopped, traffic stop in March of 2023, if I believe. And he had all his drugs on. And then he was charged with it the following January or February. Why?
I don't want to answer that without investigating it, but what I would guess happened is that they arrest them, but then they submit the drugs for testing, and then it comes in not as an in jail to our office, meaning somebody's been arrested, you need to act quickly, but it comes in as a basket case, and we wait for the lab results to catch up to it, and then charge it at that point. So that is not uncommon, unfortunately. That is just the reality of the criminal justice system and numbers.
A lot of what we're seeing, I think, is just that, the reality of the justice system, which is, as we look at it, as those of us who are outsiders look at it, it's just far from perfect. And another example of that is with Taylor Freeman, who assaulted Lola brass knuckles, got arrested, went to jail, got out, and did it again 10 days later. And his dad is in the police report saying, I don't know what to do, looking for help. And so why isn't the justice system providing that?
I share that frustration. One of the loopholes that we tried to close this last legislative session is, so kids obviously are not allowed to possess guns, with some exceptions. You can possess it to hunt or for some sort of sporting. You're also allowed to have a gun in your own home or group home, in your own residence. What the law doesn't say is so long as your parents are okay with it. And we've actually had parents calling the police saying, my child has a gun. Could you come get it? Because bad things are going to happen. And the police have their hands tied because they're allowed to have a gun in their own home. And it doesn't say as long as you have parents' permission. So we tried to close that loophole this last legislative session, and it didn't get through the legislature. So we're going to try it again this next legislature.
It seems like a no-brainer, bipartisan rule, right?
That's when you get suspicious that it's going to fail, then it's a no-brainer. It would be great to have your listeners, to have people like yourself kicking up some dust about that, because the NRA, we approached them and they stood neutral on it. Or one of the gun lobbying groups actually supported it. It wasn't the gun lobby or anything like that. I'm pro Second Amendment. It's not that. It just, we need people kicking up some dust and saying, this has got to stop. Because here's the thing. Once you get into adult court, whether you get there because you turn 18 or because the offense is so serious that we put you in adult court, it's a whole nother game. And I think we all want juvenile offenders to be treated and to be rehabilitated, really rehabilitated, and get back on track. And that's certainly, it's a false kindness to say, oh yeah, go ahead and have a gun whether your parents like it or not.
But why does the justice system allow for something like the Taylor Freeman situation to occur, where parents are, they don't know what to do?
That's one of the things that I want to work on in this upcoming 4 years, because one of the things that I have seen is, I think people get lulled into this sense of complacency. And so you have juvenile courts that are sentencing kids to programs that maybe they worked 10, 15, 20 years ago, but this is a different generation and they don't work anymore. And one of the things that I came across when I took over was that kids that had guns outside of the home were given a workbook to fill out. Now, I can't imagine that working with anybody. And I actually made the point, I'd rather you do nothing at all than make the criminal justice system a laughingstock to these kids, because you're not doing them any favors. So I think we have to seriously reevaluate this generation and these crimes as they have changed, as we've talked about, to make sure that we're not just checking a box, that we're actually rehabilitating. And that's one of the reasons we hired a statistician into our office, because I said, I'm not doing diversion to do diversion and say we did something. I'm doing diversion to divert from being a permanent part of the criminal justice system. I want it to work. And it does.
That's good news. We want things to work. We want fewer criminals. We want fewer people in jail.
And especially young people. No matter how you look at it, Preston's death is a tragedy, but you have 7 young men, and I'm not saying they don't deserve it, who are indicted for first-degree murder. That's awful. It's appropriate, it's just, but it's an awful fact.
What else do you want to address that maybe other candidates have said? And then I want you to tell people why they should vote for you and what they can expect from you if they do.
Okay. First of all, you're looking right now at somebody who has spent 32 years in the office. And I recognize that people look at that and go, you're a government employee for 32 years. But let me tell you what I've done with that 32 years. I've worked my way up from a law clerk in the office. I've been a bureau chief. I've been a division chief. I've been in charge of the office before when Bill Montgomery left. And it is a passion of mine, and I view it actually as a calling. I spent 25 years of that protecting kids, and I've been recognized for my work in protecting kids and protecting adult victims of sex assault. And I bring that experience and I bring that passion to the office now. When I took over the office, we had 20% down in personnel. We had massive backlogs of unreviewed cases, unreviewed officer-involved shootings. Those backlogs have been eliminated. The personnel numbers have been gotten up. We had bad police relations. I'm now endorsed by all of the major law enforcement agency or unions in the state, 9 in total. And, they have faith in me. They're not endorsing me because they think I'm liberal or weak on crime. I am a native. I grew up in Phoenix, went to Grand Canyon University, ASU Law School. I have seen what's happened in other states that have tried liberal policies, and I have no intention of bringing them here. And even with businesses and organized retail crime, I'm supported by the Greater Phoenix Chamber of Commerce, the Arizona Chamber of Commerce. Arizona Retailers Association recently gave us an award because I want to keep this a place that people can live, they can feel safe, businesses can do business, and that people want to come to. There are places in this United States that I used to love to go to that I don't want to set foot in. And that's never going to be Maricopa County under my watch.
Awesome. Well, thank you so much for your time and for being willing to answer some what could be uncomfortable questions. I really appreciate your transparency and honesty. And everyone needs to know the primary ends July 30th. Please get out and vote.
Absolutely. And I would say that for any primaries decide most of the elections. So please don't blow off the primary. I know it's hot. And Billie, also another thing I would say is we have a Citizens Academy at the Maricopa County Attorney's Office where we walk people through some of how our decisions are made. And so people if they want to reach out to my office and sign up for Citizens Academy, we do them 4 times a year, get great reviews. So please do so. Happy to have you.
Thanks so much for listening to the Modern Divorce Podcast. Remember, anything you've heard today or anything you read online is not the replacement for actual consultation with an attorney and does not create an attorney-client relationship. Even if you called in and we spoke to you, you were anonymous and we don't have your details and you have not become a client of Modern Law. However, we would love to speak with you, or you should seek out the advice of legal counsel or counseling or any other expert near you. And if you have an idea for a show topic or you need to speak with an attorney in Arizona, you can reach me at info@mymodernlaw.com.